Okay, so without further ado, we're going to turn the presentation over to Valerie.
Good morning, everyone. We're going to change let's go to the next slide. We have the next slide has both Janet and I's email addresses, so if you wish to contact us with any questions after the fact, this would be the best way to reach either of us. Go to the next. So today we're going to be talking about VAWA, the history, the updates that have happened over the years since its original passage. The purpose, we're going to talk about the housing protections that were included in the 2013 VAWA renewal. Janet will be covering some issues regarding implementation for ESG grantees, and then we're going to provide some resources that you'll be able to use to help you with the implementation. So let's talk about VAWA. So VAWA was created, was first passed in 1994. Its purpose was, first off, to acknowledge the national growing concern for issues relating to victims of domestic violence. In particular, the act was to help improve the criminal justice response to domestic assaults, expand services on a national basis, and to increase protections for victims. And so what you're going to see when we talk about this is really about increasing those protections for victims. So over the history of VAWA, it's been passed every 5 years. And just for those who may be following, you may know that the current version of VAWA expired in 2018. But please note that all of the laws relating to VAWA are still in force, even though the act itself has expired. A new one has been submitted for consideration and is being debated now. So over the years, beyond domestic violence, it was expanded to include individuals who have dating violence, those with child in common, those who formerly were dating, the victims of sexual assault and stalking. Please note that when you're talking about sexual assault, we're not talking about victims who have been forcibly raped. It can include non-consensual sex. And it is extended to any victim regardless of their age, sex, gender, identity, race, national origin, family, familiar status, disability, or sexual orientation. Many people will say, well, violence against women, what about men? Violence Against Women Act also includes male victims of these crimes. So over the years, some of the most notable changes relating to housing have been, for example, in 2005, personally identifiable information, PII, was protected. Most people know that about the inability then for domestic violence programs to enter data into HMIS. Many of the protections, well, all of the protections we're going to be talking about for the remainder of the day were first passed in 2005, but only applied to public housing units and Section 8 units. In 2013, those protections then expanded to the VINTO Act funding and home funding, which is why we're here today. It expanded protections to individuals affiliated with victims. So, for example, if that household included parents or siblings, children, or any other person living in the household, the protections then expanded to the whole household, not just solely on the individual victim. So what we know of as Title VI of the VAWA Act specifically calls it safe homes for victims of domestic violence, dating violence, sexual assault, and stalking. And it was passed in 2013. HUD had not completed their review of the Act and how it would impact housing until that was finalized in November 16. And that's really because, if we all know who've been involved in these things, it takes a long time to publish, position and get comments and incorporate all of that. So the provisions that we're talking about actually were in effect December 16th, 2016. And for ESG contracts, they actually applied to contracts that were entered into in 2017 and CoC contracts that were entered into 2018. Part of the problem was that we had administrative change. Many of the forms that we're going to be talking about, and we're going to show you later, or you'll have links to, are all expired and outdated. They're supposed to have been updated by now. They are still a work in progress. They have not been. So when we talk about the forms, we're going to talk about, you know, how we need to make them current and up to date for our communities, but know that updated forms will be released at some unknown later date by HUD. So the types of housing that are covered. So for emergency services grants, we're talking about rental assistance and homeless prevention. We're talking about tenant-based rental assistance. Under continuum of care funding, we're talking about housing first, rapid rehousing, transitional housing, permanent supportive housing, housing supported by the Housing Trust Fund. And this is inclusive in that any privately owned HUD-assisted property is covered by this act. Please note that emergency shelters and safe havens are not subject to these rules. So, the protections. So victims cannot be denied, evicted, or terminated due to adverse factors relating to their victimization, such as job history, credit history, criminal history, and rental histories. Individuals can still be evicted from properties, but it has to be limited to those violations relating to the lease agreement. And so when individuals are looking at assessing an individual for eligibility, they can't screen them out for these reasons. And I think that some telling part of that is HUD guidance in the ruling itself. If you pull up the actual HUD federal ruling on this on page 8728, there's a statement in there that refers to the HUD 2003 Public Housing Occupancy Guidebook, which encourages staff to exercise discretion, including inquiring regarding the circumstances for any negative reporting that comes up when you're looking at whether to evaluate someone for eligibility, to determine whether that negative report was really caused by the fact that they were a victim of domestic violence. And they suggested at that point that maybe it might be a good idea for many providers to work with a victim service provider expert to help train staff who are making those decisions, those evaluations, you know, assessing somebody for eligibility to have a broader understanding of the impacts victims experience from domestic violence. So the tenant eligibility rules were not changed. So to be eligible for the projects, it's still the same eligibility. It wasn't impacted by VAWA. Note that the VAWA protections remain with the tenant as long as they remain in the property. So if they were placed into a property and they're no longer receiving a HUD subsidy, as long as that initial lease was signed with a HUD subsidy with the VAWA lease addendum, that those protections still continue with that individual. And you cannot penalize a victim for continuing or reestablishing a relationship with an abuser, even if they are not listed on the lease. Note there is not a requirement in any of the provisions that convictions are required for any of the different pieces, aspects of the protections that are provided by this act. So some of the provisions of VAWA protections include confidentiality, and I already mentioned the issue of the personally identifiable information not being entered into a database. The personally identifiable information is also protected in your file maintenance, in your review by monitors to look at determining eligibility. So it expands beyond just the issue of being protected just in the database. It also talks about how documentation of requests for VAWA protections are maintained in a safe way, and also issues relating to the release of information, what can and cannot, and how it can be released. So we'll cover those three different aspects to further understand the VAWA confidentiality protections. So as I mentioned, as 2005, personal identifiable information, date of birth, social security number, address, name, cannot be entered into a shared database, and cannot be shared or stored in a manner that allows for unrestricted access. If you have someone coming in to do monitoring, a funder, the file should be redacted, and all of the personal and identifiable information should be reviewed. And this is very specifically stated in the HUD guidebooks that redaction of PII information is allowable to, and still allows an auditor to determine eligibility documents. So documentation requests for VAWA providers. So a provider may require a tenant to submit documentation. There is not a requirement that they have to. You know, often the standard best practice is to believe. If a victim comes forward and tells you that they're a victim, the best practice is to believe them. But in certain situations, some organizations may choose to request documentation. Of the documentation that is suggested by HUD, what they're also stating is the victim should be able to choose from that menu of documentation which type they submit. Third-party documentation would be limited to cases where there would be contested claims of abuse. So you have someone who has come forward for the emergency protections, and they have stated that the other adult resident in the home has abused them, and so they file for those protections, and the other adult now claims it is actually the other person. In cases of contested claims, you can require some sort of documentation, third-party documentation to do that. Under no circumstances can you require a victim to have a PPO or to get one. And there's a really good reason for that. Oftentimes, seeking legal remedies can be a trigger for further abuse by a perpetrator, and so the victim is in the best position to know whether or not that would be a safe course of action for them. So it is not up to us to prescribe that that is the direction they should go. So documentation options on HUD certification form 5382, and you will note that when you go look for that, you Google that, it will come up as expired, but these are the options that a HUD housing provider or a housing provider must accept, and this is that list, and that is a document that is signed by the victim and a victim service provider or a mental health provider that includes a statement that they believe the incident or incidents occurred, a documentation from law enforcement, court, or an administrative agency that may have responded to or have knowledge of the family situation, or a statement by the applicant. Again, none of these are required. These are all optional. And of those three, if you are going to require, if you're going to ask for documentation, then this is the list you can use, and that the victim gets to choose which of those three they will be providing as documentation. So when we have contested evictions, this is where then the owner or the housing provider has the right to ask for two different third-party documentation, and that they have 30 days to provide that and resolve that conflict. So release of information. So the VAWA Act requires these provisions for any release of information relating to a victim of domestic violence. First off, any release must be signed by the victim. And there are some protocols about if you're managing something over a long distance situation, how to document verbal affirmation over the phone, but that does need to have third-party documentation, more than one person who hears that statement, to be able to do that. Best practice is that you actually have their signature. it must be time limited. And when VAWA refers to time limited, it isn't 6 months. It isn't 90 days. It is a specific time limit that is related directly to the information that will be released. Ideally, the shorter, the better. So it can't say, you know, well, they're in our housing program for a year, so this release is good for a year. That is not an acceptable time limit. It must also be limited in scope. So as opposed to saying, you know, the release will authorize any allow me to discuss any housing issues. What it has to say is specifically what housing issues. If you're trying to seek information about credit history, it has to be say specifically to seek information to identify this specific aspect of a credit history. So it must be limited in that scope. It must detail exactly what is being released. It must state to whom. So it has to state a name. It has to state a date and a time frame and how it was delivered. Is this going to be delivered by fax? Is this going to be delivered by mail? Is it going to be delivered in person? It needs to be very detailed and specific. And a release would be necessary even for like an eviction or termination of services. If you have a requirement, let's say that you know that part of the family involvement may be CPS. So CPS is requiring that if this person's losing their housing, you have to notify them. You have to include the victim in that notification, and you have to have their consent to move forward. So file maintenance. So if someone requests a VAWA protection relating to their housing, it is very specific that that information should not be included in their tenant file, that you should create a file that is completed and maintained in a separate location that has limited access. This is sort of like when you think about personnel files best practices, they don't include any request for medical documentation. It would not be included in your personnel file. And this is so that the tenant file could state all kinds of information. You would read it, you would not know that they were a victim. But if you put that information where they requested these emergency protections, you would then know that they were a victim of that crime. So the practice and what HUD is requiring is that they should be kept in a separate location and that they should be limited access. So we're getting into the key components of the VAWA ruling and housing protections, and we're going to talk about notifications. How do you make sure that victims know that they're eligible for these protections? And two of the protections that we're going to talk about that really focus on the ruling are requests for emergency transfers, and another one that I think there's not going to be a lot of that issue, but at least bifurcation, we're going to talk about that and what those two things allow victims to do to keep themselves safe. So first, starting off with the required notifications, HUD 5380 is their sample housing rights form that every individual should be provided. The notification of these rights. The document is allowed to be modified to make it specific to the local area. And that document should then include what type of housing are they providing. Are they providing, homeless prevention assistance? Are they providing rental assistance as a lease? Or whatever component that you're providing them, that should be listed. And also any information regarding the program operations information. So, example, where would they go if they had a problem? Who's the contact? What's the telephone number, email address? So specific information about the program operations. The things that cannot be changed in this form are the VAWA protections and confidentiality provisions that are stated in Form 5380. Those must remain intact and cannot be modified. So you give out the housing rights notification at the annual recertification with any notification of admission, denial at move-in. So once again, and then if you were terminating the individual from the program or the household from the program, you would give that notification but you only need, in that case, to give it the first time that you send out notification of termination. It doesn't have to go with every additional termination notice. HUD highly recommends that you develop a documentation process to support that you have followed these provisions and that you've provided the housing notifications. They don't have a sample form, so it will be up to each community to develop, or each housing provider to develop their process for documenting that the individual received the notifications. I think sometimes just simply a form that, you sign off that's saying, here's a list of forms you were given and that you sign them, probably would be sufficient, but they're not specific in the ruling as to what that form would look like or that process for documentation. You should easily, to support that, you should easily have a written policy, and that, in addition to the form, would provide some pretty solid documentation. That would be my recommendation. So housing rights, another thing you could take a look at, one of the things is that they suggest that not only does the individual receive information about those housing rights, but the housing rights should be on display in your facilities, and that it should be, maybe out available, your policy, for anyone to take. So the National Housing Law Project actually has a really nice trifold that they put together. Annually, they have been updating it, so it does contain the most up-to-date information. And it comes in both English and Spanish, which is lovely. The only thing that I would suggest that if you use this is to find a place to put your local information, because that trifold, if someone takes it and then realizes they need to utilize it, does not connect you, that individual to your local organization. So if you use that, I would find a way to, like that nice spot there on that back side, being able to put your local contact information would be the most helpful piece if you're trying to, make yourself easily accessible to victims. And the link to that is right there. So the other piece is the VAWA lease addendum, and this is a link to that form. It's 91067, and this is an addendum that should be part of the contract between the tenant and the landlord, and this should be attached not just to victim leases, but every individual that you're providing housing assistance to, that it has a lease involved in it, this lease should be included. And the main reason for that is you don't know who really is a victim. There are many people who come through the housing assistance process who have not identified themselves as a victim. And so we can assume that this information wouldn't be pertinent. This can be modified. Right now, it only has signature lines for one, and the requirement is that it is signed by every adult in the household. It is one of those things that HUD is said that they will be, when they revise the form, it will include additional, but I would definitely, look to making that a local process where you could do that. And again, this is a form that if you make any edits to it, you cannot make any changes to the VAWA protections and the confidentiality requirements. So one of the two options for victims who are in a housing situation where they are, they need to make a housing change, the first one is emergency transfer. And the model policy is 5383. This, again, is the link to that. But please note that you cannot just adopt this model policy as your local policy. It would not be an acceptable policy according to HUD's regulations. The form that is provided by HUD is for guidance only. And the plan should not be distributed to clients, but it should be available upon request. HUD recommends communities, as they're developing their local model policy, to certainly take advantage of the technical assistance that's available either through domestic violence programs locally, through HUD, through state or national coalitions. I know Janet and Christina and I all sat in on a webinar a couple weeks ago, and the two agencies that they were focusing on both were receiving HUD technical assistance to develop their protocols and processes. And that one, you can go to the HUD Resource Exchange site, and that webinar would be available for you to preview if you want to hear how some of the local organizations, a couple of local organizations have adopted these provisions for their community with the assistance of HUD's technical assistance. So what is an emergency? And this comes right again from page 80801 of the HUD's final rule. It is the tenant's reasonable belief that there is a threat of imminent harm for further violence if the tenant remains in the unit, and that the tenant is occupying, and in the case of sexual assault, that the tenant believes there is an imminent threat from harm for further violence, or the sexual assault occurred in the actual premises, that unit, or if it's a complex, that facility. So emergency does not have a definition in the VAWA regulations. What HUD is stating is that all requests should be considered emergencies, and that tenants requiring a request for emergency should not go to the bottom of the wait list. That an emergency means imminent danger, and that home is no longer safe for them to stay in, and the plan really needs to address how are you going to assess that individual, leave that facility as quickly as possible, and then get into a safe space as quickly as possible. So what is imminent? So imminent, according to HUD, is defined as, in the rule, as actual danger that is real, might occur immediately, and could result in death or serious harm. And is one of, I thought was really interesting, the word acuity was used a lot in the last webinar we all attended, just to look at, like, we all have a wait list, and everybody on the wait list is a priority. But when you're, at risk of, life or harm, that becomes an acuity situation that is much different than the fact that everybody needs a home, and that is equal. So there are two types of transfers. One is internal and one is external, and this language, again, comes right from the HUD ruling. But the basic difference is an internal transfer would not require someone to have to go through the application process. So it could be a facility that may have, may own another facility that would be an alternative to move somebody to, or it could be a program that has space in their list to be able to immediately move that person over to another unit without having to go through the application process. The external application, it definitely would be more time-consuming because it would mean that there isn't space where they're at now within that program, and that you would need to find another space and also go through the eligibility process. So that one, it would definitely be much more time-consuming, and your policy should address both of those. How do you handle that, again, so that you're helping that individual relocate as quickly as possible? So your emergency transfer policy should include the following items that are on the next two slides. And again, this comes right from the list that's within the HUD ruling. It must detail the level of priority given to victims requesting a transfer. So how are you going to, how are you going to manage that with your wait list, and how are you going to, what level are you going to give them? You need to define that. What are your policies for assisting victims when a safe unit isn't readily available? Do you have any MOUs with other covered providers that can help you quickly move individuals to a safe place? Do you have any outreach activities or partnerships with your domestic violence service agency in your community to ensure some really good, solid assistance to make sure that the victim has support in the process? And you must maintain, for a minimum, retention of all transfer request documentations for 3 years. Again, this would not be contained in the tenant file, but in a separate file. You must have strict confidentiality provisions, and you need to detail how you're going to maintain the confidentiality of anyone requesting an emergency transfer. So you have to have, what is your policy for assisting tenants? You know, some communities on the webinar were talking about, well, they have a connection with their local DV program, and immediately that domestic violence, they have an agreement with that, that program comes in and assists. And others, you know, have specific staff person, not any staff person, but a specific staff person that is assigned to assist with any emergency transfers. So this is really just kind of diving down what you have in your community, what will work for your community, and defining that. HUD says that the victim will define what a safe unit is, so it can't be your community saying, well, we have this unit, it's readily available, it's not anywhere near where they were living, so that should qualify. And again, the victim needs to be able to determine what is a safe unit, and that may be because they know a whole lot more about where that the perpetrator hangs out and lives and where family members are and things like that. So just because it's a readily available unit does not necessarily mean, and it's different, does not mean that it's safe. And you need to follow the lead of the victim on that. And that needs to be stated in your policy, how you're going to help address that. It may require tenant documentation. And again, I refer you back to slide 16 about what type of documentation is allowable. It should state how a tenant would request a transfer. What's the process for doing so? And what happens to non-transferring individuals? So we have the leavers and the stayers. So the victim is leaving, what happens to the individual who is staying there? And again, that last webinar was really very clear that you know, we're about addressing homelessness. So it isn't about you evict one person on the street and they become homeless and the other person has a house. You have to have a plan for how you're going to ensure that no one ends up homeless as a result of these transfers. Is there any role for your coordinated entry in the process? If so, you need to define that. And would moving costs be covered? It's not required, but if you cover moving costs currently under any of these programs, then you can't deny it in these cases. If you're not covering it all, then you don't need to cover it. But you need to address that in your draft of your plan that you're going to put together. So then we get into this bifurcation of the lease. And so what could happen if you have 2 adults and instead of one person just going off into their own unit, what you could do is you could actually take the lease and divide the lease in half. And now you're housing 2 separate households. And the basic thing that happens with the lease is that the lease details remain the same. So if they're 3 months into the lease and it's a 12-month lease, they have 9 months remaining on either of those leases. The dollar amounts, all of the other conditions remain the same. It has to be done in accordance with any local laws regarding the housing unit that they're in. And if you have an issue where the only one adult household member, if maybe that's the abuser, is the one who was eligible for the housing unit, you have to allow the other individual 90 days to document eligibility to also be eligible for that particular program. So you have to allow the individuals to stay, the remaining tenants who are not already eligible, time to establish their eligibility and or find alternative housing. So immediately when you bifurcate the lease and it goes off with one person, doesn't mean immediately that there's an eviction for the other family. They may require documentation, and again, you refer to the list on slide 16 of what kind of documentation a person could request for bifurcation. So you have contested evictions. So it may be that, both families, the family is in a unit that is being supported by your program, and both adults are on the lease, and now you have one person who's saying, I need an emergency transfer, or I need a lease bifurcation because of abuse, and the other person, maybe they're not eligible to stay in that same program, and so they would end up not having the same subsidies. They may contest, being identified as the victim. And so that process then can require third-party documentation. It does, the rules allow for 30 days to resolve and work through that conflict. If there's conflicting evidence, the owner may then deny continuation or entry into the program itself. So we're to frequently asked questions.
Hi, this is Janet, and I want to thank Valerie for that great background and information on the VAWA. And I'm just going to go through now some frequently asked questions and then kind of zone down onto the Emergency Solutions Grant and how we're going to roll this out for you. The first frequently asked question that came up a lot as we were looking through this is something Valerie just spoke about. And what if you need to get the abuser out of the home? It's important to remember here that this applies to ESG rapid rehousing only. I mean, it applies to other programs like Valerie was saying, like home and Section 8 or the HCB vouchers and everything. But for us, when we're talking ESG, it applies to rapid rehousing. And it's important to note as well that this rule protects everybody in the family, not only just the person whose name might be on the lease, but also if it's a male, then the female who's in the house, or if there happens to be an older individual there who could sign a lease and that person's being abused in the house, like if something's happening to them, we can also assist them with getting another unit. What HUD noticed and CSH on their last webinar is it's very important to realize here that we're helping homeless people. So even though they came on ESG as, that way, as homeless, so if we bifurcate the lease, it's very possible then that because they were homeless, they're still going to have that status. And we're just doing the 6-month leasing assistance. So we are going to give the head of household probably housing and also the person that was abused, because, you have to look at it like they're both still, one's homeless, right, and the other one's saying they're being abused. So it's very likely in this situation with ESG and the short-term leasing assistance, bifurcating a lease might mean just giving them both assistance for a while. Unless something happens where somebody may end up in jail or something like that for what they have done, then obviously they don't need the housing anymore. But so this slide anyway just talks about what do you need to do to get somebody out of the house, and you would go then to the HARA and work with them. But then the people that are still there, like Valerie was saying a few minutes ago, they have 90 days or until the end of the lease to establish eligibility under the ESG program. The next slide talks about what happens if the abuser also submits certification claiming that he or she is the victim. That's when you might have to dig down a bit and get a police report or something. You'll have to go a step further in figuring out who did what and like that, and that should be spelled out in your emergency transfer plan probably, and see what you can get from the person who has been abused or the person who says they've also been abused, and just try to work it through. Next slide talks about housing authority or landlords required to tell me about VAWA protections. Yes, this is mandatory. That when you see this, as I go through the next slides, what you are going to see is that for the ESG program, there's basically 3 required things. First one is that you give the tenant their rights when you put them on rapid rehousing. You're telling everybody, and not just people who prior victims or anything like that. It's every rapid rehousing person is going to get something that they're going to sign off on, or you're going to do a checklist on that says, yes, you gave them that information. They know all their VAWA rights. You're also going to give that to every landlord. So the tenant and the landlord are both going to get these like pre-cut forms. Another thing that's going to happen is there is a MSHDA 21, and that's something you're already using. That's the lease. There's going to be an addendum attached to that speaks to VAWA. So the landlord has that information and the tenant has that information on that lease agreement. What that is going to do is going to just protect you, like, so that HUD comes out and monitors you, or MSHDA comes and monitors you. You said yes, you can say yes. I definitely let the tenant and the landlord know their rights. And here's my lease, my signed lease, which has an addendum on the back. So that's how you're going to prove that you've done your thing. Next slide talks about another frequently asked question. Landlords can treat tenants like if they're not paying their rent or they're destroying the unit, things like that. Even if they are a victim of domestic violence, they're treated like any other tenant in those respects. So a landlord can terminate them for lease violations that are just what happen all across the board. A landlord cannot, as Valerie was saying, evict just because they don't want to deal with somebody that's been abused or like that. Then that's different. But another way that they could be evicted, a landlord could evict, is say, for example, there's an apartment complex, and Valerie, you can jump in on this if I'm not describing it correctly, but there's an abuser there who's really extremely violent, and the landlord is worried about other people that are living in that complex because he is so violent, she is so violent, and they have a gun and they're afraid their entire apartment's going to get, people are all in danger. Then they might want to work with the person who's being abused and move them to another unit so to keep the apartment complex safe. Does that make sense?
Yeah, it does. I think it just really goes back to the imminent threat. Do you really believe that there's a serious risk of harm? And if there's a serious risk of harm, you can remove somebody or evict somebody from the premises for that. But it can't just because, domestic violence situations can be dangerous, and I don't want that to be in my facility. It can't be that simple. I mean, it has to be really demonstrated, and this is where that documentation makes a lot of sense.
So again, for ESG, we're just doing what I call a soft rollout. And the reason we're doing this is, like I said earlier, is that MSHDA wants to get folks going down the right path. Okay, so what we mean by that is effective May 1st, all rapid rehousing ESG recipients are going to have to receive their notice of tenancy rights. The landlord's going to receive his rules on that, and there's going to be an attachment to the lease addendum. That starts May 1st. And that slide, those are forms that MSHDA will provide you, and you'll receive them in April sometime here. We're working on those now, and you'll get those. So that's kind of the soft rollout of it, just kind of covering yourself and getting to know and understand the program. Also, as we were talking earlier, those are the 3 required forms, but there's also a HUD 53, 81, 82, and 83, and you can use those as you find them necessary to use. They're not required forms at all, but they will help you work through processes with tenants. So you should have those available to you and understand them. So the what's next slide, again, I'm being very repetitive here, but effective May 1st, there's the lease addendum, the notice regarding the tenant and applicant's rights, and the notice that's given to the landlord. And then, as you know, the ESG lease, or the ESG program regenerates itself, or kind of you get a new grant effective 10/1, October 1st. So by then, when you submit your Exhibit 1, you're going to have with that what's called like how you're going to deal with it. Like Valerie went through some slides, and it's called an emergency transfer plan. It's on, there you go, it's on slide 46 that you have, that is on your screen right now. And that's not due until October 1st or 9/30 with your new ESG application. And Valerie talked about what's required in your emergency plan on slides 29 and 30. So on that, in that plan, it's kind of, that really digs down, or drills down, I should say, on how your local planning body or continuum of care body is going to deal with this situation, and how you're going to prioritize and work with folks who end up who are victims. So again, for the ESG program, just to summarize again, it applies to the rapid rehousing that you're doing. Since folks are all homeless that come through and receive rapid rehousing, in that respect, it's a little bit easier than if you're doing a Section 8 voucher, because that's such a long-term subsidy. With this, they're all homeless. So if you have to split up a lease, even though somebody was a perpetrator, you're probably still going to be helping them because they were homeless. And then it's kind of up to the courts to figure out who is in trouble or who needs, protections and those kinds of things. So I guess I will leave it at that and just see what questions come about. So if you have any questions, just feel free to type them in.
So there was one question that was typed in that asks if the VAWA protections are for all clients who identify as a DV survivor.
Yes, very simply they do. But you can assume that you know who is a DV survivor. So many of these provisions as far as notification, the lease addendums, still have to be utilized for every person in the program, so that notification, that information goes out, because maybe they're not a victim when they enter the program, and maybe they become a victim while they're in your program. So they need to know what's available to them.
Yep. Again, anybody who comes through that gets rapid rehousing with the Emergency Solutions Grant Program, you don't even have to wonder if they're a victim or not. You just always give them their rights and do the lease addendum. The other thing that we spoke about a little bit earlier too is the confidentiality. And when MSHDA or HUD comes out to monitor you, they're going to want to see that you have kept all that, any material relating to domestic violence in a controlled area. It's confidential. You're not entering names like that, so they're identifiable. So you're going to have to keep that in a separate filing area, not in the regular tenant file. MSHDA will be guiding you through this through the month of April, so that you can attach, you understand, so that you know what to do with the soft rollout, and then again you have until 9/30 to create your emergency transfer plan. We'll probably give you more examples too. On the webinar that CSH and HUD did, they gave some really good examples of emergency transfer for material, and we can forward that on to you.
I think that would be a good idea. Those were both those webinars were very good.
Yeah, those webinars were good, and the homeless specialist and we're all here to help you sort of implement this and make sure that you're checking all the boxes and helping everybody as much as you can.
And I think if you're going to reach out to this, if you're going to reach out to me, my recommendation would be to email me and include Janet so that we can work on this together. I think it'll speed up the process of communication if we're both knowing what the issues are and what the questions are.
Is that it? We don't see any more questions here, but we're available anytime here, so you can just email Valerie or I. Thank you for your participation today, and have a great day.